Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from New York. And in today's video, I'm going to be talking to you about the most recent immigration news. So please join me. If this is your first time here, welcome. I am practicing attorney from New York. I've been practicing immigration law in the United States for almost 15 years. And I regularly have this live videos where I share with you the most recent immigration news, my perspective on those events, and I share tips as well and answer your questions. So thank you very much for joining. Let me know where you're watching from. Like, share this broadcast so more people are going to join us. I see people are joining. Thank you, guys. It was always nice to see you. Hi, Shafiq. Hi, Malik. Hi, Lian. Hi, Shahzad. Hi, Ali. And don't forget to let me know where you're watching from. How is everything there? Hope everything is good. And today we're going to discuss a number of things. We're going to talk about just the most recent updates. We're going to talk about something that is happening with regard to DACA, and this is going to be the first topic. Well, recently I received updates, and I'm sure many immigration lawyers as well, with regard to DACA. In other words, USCIS is finalizing its rule on DACA, or Deferred Action for Childhood Arrivals, because, as you may be aware, the lack of a clear rule and the lack of adequate notice under the law on DACA was the cause of the litigation that jeopardized DACA for tens of thousands of recipients and beneficiaries. You may be aware that currently, if you qualify for DACA, you can submit your application. It will be accepted, but it will be placed on hold if this is the first time you're filing for DACA as a result of that litigation. If you have already DACA status and you need to renew it, it's not your problem, thankfully. You will be able to renew your DACA status, which is very, very good. But new applications are being accepted but not being granted. And here I just showed you this new announcement that this new final rule on DACA is going to go into effect on October 31st, 2022. But if you see on the screen, there is this disclaimer that because of the lawsuit that's almost 1 year old right now, an injunction, new DACA applications cannot be granted, but can be accepted. This rule, unfortunately, did not change qualifications for DACA. In fact, this announcement that we received today states that this rule maintains the existing threshold criteria for DACA. It means that you would have to qualify for it under the standards that were first announced almost 10 years ago. In other words, you have to show that you've been residing in the United States prior to or since June 15th, I believe, 2007, and so on and so forth. Usually people who are in the United States, they already screened themselves for this qualifications. And I actually find some people sometimes who still qualify, they never bothered to file for DACA because they were worried that they will not be able to prove physical presence or continuous presence, and they missed their chance of the initial grant. And now, of course, it is on hold. But I'm going to tell you something. If you do believe that you qualified for DACA, please apply. Even though your application cannot be granted at this time, hopefully United States Supreme Court is going to rule in favor of DACA recipients and beneficiaries and potential recipients and beneficiaries. And you'll be able to benefit from it as well, okay? Even though now it's late, of course, it's not going to be something that will give you some status at this time or employment authorization, but at least you may be able to save your chance. So it's important. It's important to know all those things, all those developments. And again, this rule clarifies procedures for termination of DACA and related employment authorization, retains existing requirements that the DACA applicants must file for I-765 separately or application for employment authorization. And most interestingly, also, as you see, DACA is not lawful immigration status, but it's a lawfully present. A person is lawfully present, but it's not a status that would allow you to jump from it to a different status, like student status, F1 or H1B. But recipient of DACA does not accumulate unlawful presence. It's extremely important. Hear me out why. Now is the most important part of this presentation, perhaps. If you are a DACA recipient and you received your DACA before you turned 18 years old, right? It means that, and you maintained your DACA, it means that you do not have unlawful presence time in the United States. Why? Because before 18, unlawful presence time just doesn't run by law. And once you have DACA, unlawful presence time doesn't run. It means that now, if you find an employer, you're a DACA recipient, you're a DACA holder, you find an employer, and an employer is willing to sponsor you, you should be able to, if everything else is true, that you don't have unlawful presence time, and you are not inadmissible, otherwise you don't have an order of removal against you, and so on and so forth, you should be able to travel outside of the United States if that employer's petition is granted, receive your immigrant visa or green card, and come back. This is one way for a DACA beneficiary to fix their status in the United States, not through marriage to a U.S. citizen, but through employment, okay? You will have to travel outside of the United States, but it's a chance for some people. I do meet some people who will be using this chance. So this is what's happening with DACA. Of course, we're going to know what the Supreme Court says, the United States Supreme Court says on DACA later. I believe reports state that we will find out closer to December, all right? Another important thing I wanted to share with you is this. White House pushed ICE to increase deportations amid migrant crisis. Isn't it crazy? Apparently, not only we don't have immigration reform, we also have increased deportations. Don't like that. What's happening is that it is true that deportation numbers in recent years have been much lower than during the Trump administration. But the understanding that just because of the political reasons, the Biden administration is going to increase deportations is a little bit upsetting, taking into consideration that we're kind of waiting for immigration reform from them, and instead of that, we receive increased deportations. Coupled with the situation around the prosecutorial discretion, when sufficiently ICE was prohibited from following the memo on prosecutorial discretion, and ICE has to exercise it on a case-by-case basis, so would the prosecutors in courts. I would say that if you're someone who is at risk of being deported, you should absolutely consult with an attorney and see what is it that you can do, if anything, to prevent your physical deportation from the United States. And usually, chances of someone being deported are higher if you guys already have an order of removal, deportation issued against you, but it's never been executed, or you are in removal proceedings now, for example, and the government does not want to give you dismissal or administrative closure. Perhaps you think for some reason it's not going to be the best thing for you. It happens too. Or, for example, you have some criminal convictions in the past. So then you should consult with an attorney what to do in case they come after you, right? So that's another important piece of information that you need to keep in mind when you're planning for your future in the United States and you're just trying to analyze the immigration climate and see what your actions should be in response to the changing mood of the administration and changing administrations, right? Lastly, something that is not news per se, but something I wanted to discuss because for some of you this can be helpful, and I will explain why. Here is an approval notice for a VAWA case, Violence Against Women Act. You may know that not only women qualify for benefits under VAWA, but men qualify for benefits under VAWA as well. And what's interesting about VAWA benefits is that not only it opens path to citizenship and green card, sometimes it doesn't in certain limited situations, but it also comes with deferred action. You may know that a VAWA beneficiary receives a special employment authorization under C-31 category right after their VAWA is approved. In fact, the way it's working is that you're going to receive that C-31 employment authorization prior to your I-360 or VAWA petition approval notice. So you will know your VAWA is approved before you received your approval notice because you're going to get a special work permit. And deferred action also shields you from deportation. Sometimes a person is going to have a deportation order, guys, administrative deportation order, or otherwise. Administrative deportation orders can be received, for example, if you attempted to cross the border, you were administratively removed at the border, but then you came back. So you do have an order of removal, but you are in the United States. There is a special waiver for VAWA beneficiaries in these situations, but it only applies if you can establish connection between the abuse and your subsequent entry, removal and entry to the United States. It's very difficult to qualify for that waiver usually. So a person may be stuck. A person may have VAWA benefits, but cannot get a green card. However, it's still beneficial for the person to have that deferred action and benefits. Why? Because at least they know they will not be physically deported. And perhaps if there is an immigration reform, they will be able to later somehow fix their status, depending again on the situation. So VAWA is worth applying for in many different situations. It's the only thing that's going to help a person to fix their status. Not only situation I mentioned, also it can be that a person came to the United States, never left, but came initially without authorization. Interestingly enough, if you're filing for VAWA in this situation, you don't have to show that you were inspected and admitted lawfully. Very important. But how hard it is to win VAWA? I think this is the most important question. Everybody's asking me, well, do I have enough? Do I have enough for my case? Well, here are the 2 steps you need to follow to win VAWA. Number 1, you have to show that your marriage to the person was or is real. Yes, you don't have to be divorced to file for VAWA. Then you also have to show that you were subjected to abuse. Okay? If you win those 2 qualifications, you're going to have VAWA approved, I-360 approved. What is enough is determined in each specific case. No attorney without talking to you will be able to tell you if it's going to be enough or not, because we need to see what evidence you may present of real marriage. Maybe you have somebody who can write letters of support for you. Maybe you have police reports, but police reports are not necessary. It's extremely good evidence if you have them, but if you don't despair. I had plenty of VAWA cases that we won without the police reports. emotional abuse sometimes is more than sufficient to prove that you were in fact abused. Financial abuse, emotional abuse, physical abuse, of course. If you were physically hurt by your spouse, they throw something at you, they stab you. Listen, I've heard many stories, okay, where a person would throw furniture at their partner, or a butter knife, or they stab them with some sort of a pen or something. It can be wild, but it's not necessary that you would show physical harm. Sometimes emotional harm is enough. So I would say that if you were in an abusive relationship or something that you consider abusive, absolutely consult with an attorney. You can consult with me. You know how to find me. Here is a number down there. And I will be more than happy to evaluate your situation to see if it's something that is good for you. Now, if you guys have questions, I will be happy to answer them. Let's see. Please ask your questions in the comments. Let me see. Many people are asking me about WhatsApp. Guys, we do not use WhatsApp. So if you find somebody out there saying that they're me in WhatsApp, it's not me. We do not use WhatsApp. We use just regular phones. We use Skype, but we don't use WhatsApp. Hi, JD14. My VAWA was approved in 2021 and sent my I-45 in May. On August 2nd, my case was transferred to NBC and received letter. When can I expect if they need interview? I never submit medical exam. All right. So since you never submitted your medical exam, if you are requested to email or to mail it rather, or drop it off, that would be a good indication that you probably will not have an interview. Majority of VAWA beneficiaries do not have I-45 related interview. I'm not sure why you chose to submit your applications separately, VAWA and I-45. But the truth is that you can submit them together, right? And then you would probably not have to wait for that long. But it's not necessary, again, that you will be called for the interview. But if you will be, you will present your medical exam usually at that time. But most likely, hopefully, they will just ask you to mail the medical exam. That's how it usually works. Hi, Chicago girl. Hi, Asir. Hi, guys. I do not speak Arabic, Mohammed. I'm sorry. I wish I did. Long time ago, I knew a couple of phrases. They were not good because I had friends who taught me, and when I spoke something out loud, everybody laughed. So I knew it was no good. Hi, Bilal from New York. Can I travel outside the United States after I got my green card based on marriage? I-45 changed status after I withdrew my asylum case. Can you travel outside of the United States? Of course you can. Why can't you? If you're already a green card holder based on marriage, it means that you can travel. Absolutely. Why wouldn't you be able to? Green card is more than enough for you to get back to the United States, right? Green card is necessary not for you to travel outside, but to get back. Hi, Rauf. Hi, Alina. I came with J1 and then changed to asylum. Asylum is pending for 6 years. I was undocumented for 3 months while waiting and applying for asylum. Can I get green card through green card marriage? Green card marriage. Are you referring green card marriage? You're saying that your spouse is a green card holder? Usually, if your spouse is just a green card holder, you would have to show that you were in lawful non-immigrant status through your entire stay in the United States. And I'm not sure completely because this is not a consultation. It's just something that helps you to get initial information. It's very important to know this because As a lawyer, attorneys, guys, we cannot consult you by public forum, okay? It's not confidential. But I'm going to tell you that if somebody has just an asylum pending application, and especially if they had a hole in their status, they probably will not be able to adjust status based on the marriage to a green card holder, okay? If, however, your spouse is a US citizen, then you should be able to adjust your status as long as you didn't have J1 with a 2-year residency requirement, or maybe you'll file for the waiver together with or prior rather than, filing for your adjustment of status. That's how it's done for the J1 waivers. In other words, a person who is marrying a US citizen does not have to show they maintain their lawful non-immigrant status. It's very important. Even if their status expired a long time ago, as long as they have initial entry that was legal through the point of entry, or as long as they can show that later they traveled on, let's say, advanced parole and they were paroled into the United States, they will be able to adjust their status. If their spouse is a US citizen, there is an automatic waiver, guys, for spouses of US citizens. You are forgiven automatically for unlawful presence time or out of status in the United States and for unauthorized employment. Extremely important to know that. I meet people all the time who are trying to lie on their applications, concealing the fact that they're working. And I say, why are you doing that? Oh, because some paralegal told me that I should not be telling anybody I've been working here without authorization. I said, that just doesn't make any sense. You're automatically forgiven for that. But by you concealing this fact, you look not truthful. You are lying already on your forms. This may get you into trouble. And plus, remember, guys, if you work in the United States with or without authorization, you must pay taxes. If you end up in immigration court, this is the first thing the judges are going to ask you, regardless of what application you're filing for. Are you paying your taxes? And if you tell them, oh, judge, I haven't paid my taxes because I don't have Social Security, woo, the judge immediately going to get back at you saying, but don't you know that you can get a tax ID number and pay your taxes through the tax ID? So please, 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 guys, don't make this mistake. It may cost you your status, okay? Especially if you are in immigration court. All right. Hi, Eric. Eric, I see your question about some other lawyers' fees. I have no idea. I do not comment on other lawyers' fees. I'm going to tell you that each lawyer charges what is for them is acceptable depending on their experience. There are hourly rates usually, depending on lawyers' experience, years in practice. Geographical area is very important as well. Attorneys in New York City are going to charge more money than somebody perhaps in a different area. So it depends on many factors. And I just responding to Eric. Let me see if I can highlight his question here. Who is asking if something is fair to, paid fee for while the company prepares documents, lawyer charge additional $16.50. If you ask me, it seems low to me, but again, I do not know what exactly needed to be done. So there are some requests for more evidence that are extremely time-consuming, and the lawyer is going to charge a lot of money for that, much more than $1,650, okay? So it depends on the situation. On hourly rate, I think what your friend should do is your friend should see what is the lawyer's hourly rate, and it looks like it's probably going to be about 3 to 4 hours of work here. So is it fair or not? Depends on the situation, I know that many people say, oh, lawyers charge so much money. Yes, absolutely, lawyers do charge money, but you have to understand that lawyers' hourly rate is a very high rate, and lawyers usually approximately know how much time they're going to spend on something, or sometimes they don't know that. and they're going to tell you that there is a minimum deposit, and then they go by hourly rate. So I'm going to tell you that there are people who charge more than lawyers, doctors. If you've noticed, you see a doctor for 2-3 minutes, but your bill is going to be $200 minimum, right? So it's a profession that takes a lot to earn. We spend a lot of time to earn our degree, and of course, years of experience contribute to the rate as well. In Manhattan, you can expect to pay anywhere from $400 up to $1,000 for an hour of a lawyer's time, depending on lawyer's experience, again, and other qualifications. Hi, Khan. What mean by USCIS when they say that have service request for picture? I'm not sure. Service request. Does it mean, perhaps it means that they requesting your photos? Maybe, I don't know. I'm not sure. All I can tell you is that it's a good idea for you to monitor your case, online status, and see what's happening. But online status, guys, are not always correct. You should know that. Sometimes it shows a request for more evidence was sent when nothing was ever sent to you and it never existed. Sometimes it doesn't show that the request for more evidence was sent when it was sent. So it's not accurate. It's tough sometimes. United States immigration can be tough. What can I tell you? That's why lawyers charge money, because it's very stressful. And there is no good answer, unfortunately, Ken. I just do not know what that question is. Think positive. Okay, this is going to be our last question. And I like your name. What processing time to NBC office to get approved I-45 asylum? Guys, it varies a lot. In my recent case, it took us a year. I know people who call me and tell me that for 2 years they cannot receive their green card based on asylum. So I'm not sure why it's happening. Some cases get stuck like that. I think it's due to the background checks. Because when you file for that green card based on asylum, your asylum case is going to be reviewed. If in your green card application you made some mistakes, and sometimes those are honest mistakes, you forgot to mention some organizations that you were part of, you maybe messed up something else, your case is going to get stuck. You may receive a request for more evidence. You may be even accused of fraud. So please, if you want your asylum, don't jeopardize your green card. Hire a lawyer to help you to file for your green card, okay? To avoid such mistakes, to avoid these delays, because lawyers, when lawyers are working on the case, there is no guarantee that your processing times are going to be faster, but lawyers will help you to avoid, at least good lawyers, going to help you to avoid obvious mistakes that may cost you your status in the United States, especially if you have something so sensitive as asylum. Because I've noticed every time I work with an asylum client, there is a lot of stress involved, a lot of trauma. People sometimes, they just have hard time focusing on the questions or on the paperwork, because it's a very difficult process. Many people are applying for it, but it doesn't make it easy or simple. You need to know that. Asylum is extremely stressful, extremely long in the United States for most people, and you need that extra help. Somebody who's qualified, who will be able to focus on legal issues when you are going through this journey. Okay. Okay, thank you very much for watching. It was a pleasure to see you all. Please ask questions. If I don't respond to them now, maybe I use your questions for my future lives, because I see what interests you. So when next time we meet, I will be able to be more useful to you. So thank you very much, guys. It was a pleasure. Please like,